Over the last few lessons, we've been talking about the nature of the courts and tribunal system within the English legal system more broadly, and focusing on the structure of the courts and the structure of the various different levels of the courts within the judiciary. This lesson is going to touch on an issue that we have briefly examined at other points in previous lessons. This is this idea of judicial independence, the maintenance of judicial independence, the achievement of judicial independence in the first place, and the way in which the appointment of judges is done in an independent manner. So, it should be noted at the beginning of this lesson that one of the most important concepts of the rule of law, so this is the general broad idea within the UK's constitutional framework that the rule of law ought to be adhered to, as well as just the English judicial system more broadly. All of these involve an element of judicial independence and a requirement for judicial independence. The view should be that judges and the judiciary shouldn't be swayed or influenced or bullied into certain decisions on the basis of some kind of corrupt authority. Whether that corruption comes from government, whether or not government is attempting to essentially bully the judiciary into making decisions which are favourable to them, or even if it is rich individuals who are private individuals. And this is very important, given the fact that when we look at administrative law in more detail in future lessons' time, we're going to see that one of the major litigants in public and administrative law is this idea of the government being either sued or something like that, some kind of judicial review taking place, accusations that the government or the various different administrative bodies within government have acted beyond their authority, have acted ultra vires. If you had a non-independent judicial system, then this would make for a very sad state of affairs and for a violation of the rule of law if the government can be sued and they are able to influence the decision made by judges. In this lesson, we're going to examine some of the ways in which the judicial independence is achieved and maintained through the English judicial system. So let's begin with the first question. How is judicial independence achieved? How do we actually get from a position where you have probably historically a relatively corrupt system of judicial functionings to something of an independent judiciary? Well, the judiciary has a number of important mechanisms within it. Each of these mechanisms seek to ensure that they maintain a certain amount of independence, and like I said here, cannot be bullied by, for example, the government. They can't be influenced into making a decision which is favourable to the government owing to some kind of threat, some kind of carrot and a stick, for example. They can't be whipped into obedience by the government. One of the most important of these elements is something known as the security of tenure. This is arguably the most important, owing to the fact that what the security of tenure tells us is that a judge in a superior court cannot be dismissed by the government and therefore cannot be essentially bullied into submitting owing to the fact that the government could get rid of them. So if, for example, the government did have the ability to influence decisions about who and who didn't get dismissed from the judiciary, and they didn't have this security of tenure, then this would imply that the government could essentially influence a judge to give a favourable ruling in their cases for fear of being bullied and being sacked and being fired from their job as a judge. Because they have a security of tenure, that takes away that threat and the ability for the government to have any influence and any control over it. The security of tenure principle originates all the way back to the Act of Settlement in 1701, but has been introduced into primary legislation and further solidified in more recent updated pieces of statute law. We have, for example, the 1981 Senior Courts Act, which gives reference to the achievement of judicial independence, as well as the 2005 Constitutional Reform Act too, all of which achieves this idea of security of tenure. A judge can only be dismissed by the monarchy, by appeal from Parliament, something which has actually never happened within the English legal system. So you do have a very significant and quite a strong check on the judiciary, on the one hand, because they can be dismissed by appeal from Parliament, but for the most part, this is a relatively rare, and I mean, you would argue that it's incredibly rare, given that it has never happened, a rare occurrence within the English legal system. And remember, when we talk about the distinction here, is that the superior courts cannot be dismissed by the government, and so they are independent from government scrutiny. The government is different to Parliament. The government sits in Parliament, but the government is a separate entity to Parliament. It's the executive branch that we are talking about. They're the ones who get sued and who have judicial review cases brought against them, for example. The Judicial Appointments Commission, which we know was introduced by the Constitutional Reform Act in 2005, has also ensured that the appointment of judges cannot be swayed by the political actions of government. If you remember back to the previous lesson, we noted that prior to the establishment of the Judicial Appointments Commission and prior to the Constitutional Reform Act of 2005, the ability for a judge to be essentially appointed to the bench was something that was done by the Lord Chancellor. Now, given the fact that the Lord Chancellor actually sat in the cabinet at the time, suggested that they could be able to influence the judicial system by being able to essentially appoint judges who may be favourable to their legal interpretations. Now, today, the Lord Chancellor still does appoint members of the judiciary, given that they are the head of the judiciary still, but they have to do so on advice and information which is obtained by this independent and unbiased Judicial Appointments Commission. In addition to this, because judges cannot be dismissed by government owing to this previously established security of tenure principle, they are truly independent from government scrutiny. The independence of the judiciary is also guaranteed by the third section, Section 3 of the 2005 Constitutional Reform Act. What this does is instills a duty on members of the government who operate in and with the judiciary, including, for example, the Chancellor. So there is a certain general understanding that there are going to be some members of the executive branch, some government ministers, who will have to work very closely with the judiciary. At the end of the day, all members of the government will work with the judiciary at various different stages, but people like the Lord Chancellor or the Attorney General, for example, are examples of individuals who have quite a close relationship between themselves and the judiciary. And Section 3 of the Constitutional Reform Act instills a duty on members to operate, on members of the government who operate with the judiciary to maintain a certain level of independence for the judiciary. There's also a certain level of independence from Parliament as well. The judiciary is also independent from Parliament. If Parliament could just influence the judiciary in the ways that the government cannot, well, then the government could essentially vote for legislation or could vote for things to be implemented which could essentially sway the judiciary in that way instead. Well, members of the judiciary are no longer allowed to sit in Parliament. So, for example, and the most pertinent example of when this didn't happen was the original law lords who would sit in the House of Lords, but since 2009 this was replaced with the Supreme Court. Those exact same justices were moved from the House of Lords all the way across the square to the Middlesex Hall to the new Supreme Court building, putting what some people have described as some clear blue water between the legislative and the judicial branches of government. Members of the judiciary are also not involved in the day-to-day creation of legislation. They have no say over legislation which is created. Once legislation is passed, they have the duty to interpret that legislation when cases are brought to them. And so that's essentially how the judiciary operates in relation to and independent from Parliament.